वो 3 जज बेंच पे हमने वो तो डिसीजन ले लिया है that civil court need not be joined, in fact should not be joined. So here we'll say need not be joined, but they did say, it must be joined. It can be joined at the LPA stage. So now now that everybody joins, every tribunal single judge પાસે જોડી તો દેવાનું જ જોડી જ દેવાનું, પછી જે થયું એ થાય. સિવિલ જજને નહીં જોડવાના, ટ્રાઇબ્યુનલને જોડી દેવાનું, પછી જે થવું હોય થશે. રાઈટ. Then as Mr. I found that part of his talk really interesting કે 226 નીચે કોની સામે રીટ ઇશ્યુ થઈ શકે. I think everybody understands Gujarati, ne? થોડું ગુજરાતીમાં. So it was believed that only against state actors, but as Mr. Pandya points out, and several Supreme Court judgments have said, person is equally amenable, and of the people or the authorities or institutions which are coming within the ambit of 226, it's only an increase, there is no diminution. But we have one solid category which is non-state actors but who are doing state-related functions or performing state duties. And I remember this because the first case of my life, first independent case where I signed my first wakalatnama, was a student from CIPET, which is the Central Institute for Plastic Engineering Technology at somewhere. And he had failed, and એની કંઈ રીટ અમે નક્કી કર્યું કરવાનું. So he paid me a fee in installments, I remember that. And I filed my first petition extremely proudly. Notice was issued. And my ex-senior's best friend, late Mr. G.D. Bhatt, came for the respondent. And we had a 100% case, so ultimately we won it. But Mr. Bhatt did make me jump through several hoops. And nobody knew what on earth CIPET was. So he got up and took a preliminary objection. કે આ તો ખરેખર કોલેજ છે, કોલેજ સામે રીટ કેવી રીતે હોય? એટલે I remember it was, I think, Justice N.B. Patel or some such, Justice N.B. Patel. He said, Mr. Kavina, how will a writ issue against these people? So what is the best thing to do at that time? When you're asked a question to which you don't know the answer, what is the best thing to do? What is every lawyer's birthright? Ask for time. Don't brazen it out. That guy sitting 2 feet above you will crush your case. Okay? Ask for time and study. In fact, you should have studied it earlier. I should have studied it earlier. But we found out that notification of the central government Ministry of Industry establishing this university or this institute, and that notification, the Gazette publication, we produced by way of an additional affidavit, and we could show that it is squarely covered, it is state within the meaning of Article 12. But there are other authorities which exercise powers, like I believe Sardar Sarovar Narmada Nigam is a limited government company, but it is amenable to state jurisdiction, to 226 jurisdiction. So એવી કોઈ borderline case હોય જ્યાં immediately ખબર ના પડતી હોય that this respondent is or is not a state, please devote some time and effort in finding out that either it is state or it is exercising powers of the state or it is an instrumentality of the state. So Indian Oil Corporation, I've appeared for Indian Oil Corporation, and the first thing they tell me when we are taking defense is, okay, sir, we are a company under the Companies Act. That's an old argument. Supreme Court has said IOC is state. So it is state. But તમારે કહેવું પડશે. Don't rely upon the fact that everybody knows about it. So remember that. Then Just a minute. Yes, my successor speaker is here, so we won't outlive our time. Show in the first paragraph, it seems an obvious thing, કહેજો કે સાહેબ નીચલા પ્રોસિડિંગમાં હું પ્રતિવાદી હતો અને સામેવાળા નંબર 4 એ વાદી હતો. Very often when we are arguing cases, the identity of parties is not known to the honorable judge. So state this clearly. I was the respondent, he was the plaintiff, he started this, I am now challenging this order. Make that clear. Also, petitioners are nationals and citizens of India, because some rights I think under 19 are available to only citizens. So it is important that if you are claiming freedom of expression, freedom of association, freedom to carry out business, then you'd better say petitioner is a national and citizen of India. If you miss out what is an obvious thing, કે આપણે ત્યાં ક્યાં ફોરેનર્સ અહીંયા પિટિશન કરવા આવવાના છે, બટ એવું તમે ના લખો તો you will display your lack of background knowledge. Okay, so do that. Then comes the facts. Now there are two approaches here. I call them the impugned order first approach and the impugned order last approach. So the impugned order first approach is by way of this petition. It's like a trailer or the head note of your petition. The petitioner challenges Falan order, which is at annexure A. And then the other order, the other facts start from thereafter. That is one view. The other view is you start the story from the beginning. First there was darkness, and then God said, let there be, you start it from there. And then the impugned order is usually the last or second last. It's a matter of personal choice. I like to go with the chronology, so I'll start with ke pehla avu thayu, pachi avu thayu, pachi avu thayu. Every order is chronologically put. Now, that what you write is actually that group of paragraphs and those details is a piece of prose which is wearing two hats. It is pleading and it is evidence, because all your annexures are documents which you annex and prove there. We don't have the practice of proving documents as is done in civil court, but if you have any exposure to civil court, the proof of documents doesn't come as easily as it comes here. કે એ તો આપણે કહી દીધું કે annexure with and marked annexure B is a copy of ફલાણા, એટલે આવી ગયું રેકોર્ડ ઉપર. પણ that statement presupposes કે તમે જે કહો છો એ જ છે એ વસ્તુ, and you are stating it on oath, and the court takes your word or your client's word at face value, but it is rebuttable by the other side. So be careful. એટલે એ જે paragraphs છે where you write the story, and I suggest that all your annexures should be put in that set of paragraphs, either numbered sequentially or 3.1, 3.2, whatever it is. Because the proof of those documents and the story and your cause of action is in that. એનું significance એ છે કે the proper form of an affidavit, again mistakes made by me, judges point this out and you ask for leave. Affidavit must state clearly and separately that which of your information, what you have stated, is on your own knowledge and what is on your, what is the distinction, Asim? Information, knowledge? Knowledge, information and belief are not to be put together. Above is true to my knowledge, information and belief nahi. This I know to be true. This I have reason to believe to be true for XYZ reason. એટલે આખી આપણી જે સ્ટોરી છે usually, but એમાંથી there are some points which are on, you write your paragraphs of facts in serial. પણ એમાં એક કે બે એવા કદાચ પેરેગ્રાફ આવી જાય જે તમારું અનુમાન છે, which you have to say કે આ મારા, it's based on either legal advice or information which I have gathered from such and such place. So make sure that your paragraphs are distinct and all your annexures come here. Then comes grounds. Grounds of appeal, grounds of writ petition, grounds of a memo. Why what you are saying is right or what has been done by the lower court is wrong. These facts must be mentioned because, and this is not an empty matter of pleading or of formality. It is vital because the order you are challenging or whatever relief you are asking for may be available, the order you are challenging could be challengeable on more than one ground. And the respondent has to respond to that ground which you have taken. Now this is important because if you are appearing for the respondent and you know that you have to sustain an order, the order to khoto che by legal definition. But if the petitioner has not taken that contention, you don't have to respond to it. Therefore, seen from the petitioner's side, take all the contentions why a particular thing ought to be done or why a particular thing is wrong. Because if you don't, a smart respondent will defeat you and then you realize कि आ तो रही गई. And it makes great sense as a matter of broader administration of justice that what you are going to the court with, you must give notice of that to the other side. What you argue કે આટલું આટલું ખોટું છે, you must say it so that the other side can respond. Emma, just one interesting sidelight that the respondents have to respond to what is stated in the petition. But sometimes, and typically it happens with Kacha lawyers, that has happened in one case of mine, where તમને દાપણ થોડા સમય પછી થાય, 6 મહિના પિટિશનના કર્યા પછી, એટલે એડિશનલ એફિડેવિટ કે રિજોઇન્ડરમાં આપણે કોઈ પોઈન્ટ લઈએ. One petition of mine was dismissed on the ground that a point was not taken in the petition. I told the learned single judge that in my rejoinder I have taken it, આ પાને આ રહ્યું. પણ જ્યારે પિટિશન રિજેક્ટ કરવી હોય ત્યારે શું કરે જજ સાહેબ? એ આર્ગ્યુમેન્ટ રિફર ના કરે. Just doesn't refer to it. It will happen every day. So we challenged it before the division bench and we pointed out. So I remember it was before a bench of Justice Sai and somebody else, when Justice Sai was not acting Chief Justice. So I said, and his court was a court where you could use Hindi. So I said, this point is covered by the Supreme Court. He said, ऐसा principle कहाँ है? I said, है ऐसा principle. And if you type in AIR or SCC the words replication, not rejoinder, replication type karso, and replication and pleadings, so you will get this one judgment of the Supreme Court. I do not have this elephantine memory which Asim Bhai has for citations, but I told him, I said, I'll give it to you in the afternoon. So I went, and the Supreme Court had stated that if the contention is taken 4 square, maybe in the petition, maybe in the replication or rejoinder, the respondent has to answer it. And the court cannot say that this point was not taken in the original pleadings. So on that basis, my petition was allowed and all that. But he says, यार ये तो बहुत interesting है. I wish I knew this when I was a young lawyer. Because हम कितने मुकदमे हार गए इसके ना होने के वजह से. So be careful about pleadings. Mr. Pandya, I am sure Mr. Anand also, or everybody here, you take up an old petition drafted by you, and મારા મનમાં તો question આવે છે, which idiot drafted this? 10-15 વર્ષ જૂની petition હોય તો it happens. There is no way around it. I just like to think of it positively that I am perhaps better now than I was earlier. But that still doesn't, this still doesn't hide the fact that you were pretty stupid earlier. So we all make those mistakes. Just don't make the same mistake again. Lastly is the prayer clause. Now, Gujarati માં કહેવત છે કે માગ્યા વગર તો માય ના પીરસે. But it is not simply a question of semantics. As I said, a set of acts complained of or a wrong order complained of may require more than one remedy. As Asim pointed out, not just enough to quash this order, but quash it and do that. In special CAs, this fact is lost sight of. But in civil litigation, people are very conscious of this at the interim stage. So interim stage, I file a suit. My interim Exhibit 5, Order 39, Rule 1 and 2, interim relief application is rejected. Now, when I file an appeal against that to the High Court, traditional form is quash and set aside this order. But શું પણ એનાથી મને રિલીફ ક્યાંથી મળવાની છે? I always have maintained this, that the traditional view કે appealમાં ખાલી being agreed by grounds. In appeal, nobody writes a prayer also. Nobody writes a prayer. But તમને, if you are filing an appeal from order where you have not got an interim relief by the lower court, you will have to ask somebody to grant you that relief. So you better ask for that relief. Not that it's enough to just quash and set aside this decision. Or appeal may be allowed. But you will have to ask for a particular thing. And as happens frequently,